I can't hear you, Registrar.
Federal Court of Nigeria holding at Abuja Judicial Division. Before His Lordship, Honorable Justice O.O. Oyewumi, 4th Friday, November 20, number NICN/LKJ/01/2021 between Lawal Yunisa Wazawa and PLC and another.
Any of the parties, why don't you call the name of the second person? Is there any party in court?
Yes, my lord. The claimant is in court, sir.
I can't see the claimant. I can't even see you. Infinite Hot 10I. I can't see you.
I'm seeing you.
We are in court, my lord.
Yes, I'm just seeing you now. Is that the claimant?
Yes, my lord.
Very well. Defendants?
Respectfully, my lord.
Is there any representation for any of the defendants? I mean,
None,
is there anyone? Yes.
None, my lord.
Appearances?
May the court be pleased. I am Irene Ominike. I am Irene Ominike. My humble appearance is for the claimant, sir, who is present in court.
Any other appearance?
Yes, my lord. Respectfully, my lord. I am Temitope Salu. My humble appearance is for the first defendant.
Any other appearance? Any appearance for the second defendant? I can see one, Raman Olaleko.
Yes, may it please.
I can't hear you. I can't hear you. Olaleko what?
May it please for them.
Olaleko what? Ramon. Well, it's what I can see on your system that I'm writing, Ramon. You are for the second defendant?
As the court pleases.
Very well. Yes, Leonard Counsel, that is the second defendant adopted its final written address on 28th of July. So which means that the dates start counting on the 29th of July. So this judgment ought to have been delivered on either to 29th of October or 30th.
Most
so
kind.
it means it's out of time. So I would want you to readopt your final addresses.
The court pleases.
First,
okay.
Go ahead.
Respectfully, my lord, we respectfully adopt our final written address for the first defendant. We urge the Honorable Court to dismiss the claims of the plaintiff, of the claimant in its entirety. I'm most grateful.
Mr. Rahman.
May my lord be pleased. I respectfully readopt the second defendant final address we call the authority in the address to the Honorable Court in urging my lord to dismiss the claimant's action and grant the second defendant's counterclaim. We are most obliged, my lord.
Very well. Omenike Esquire.
Yes, my lord. My lord, we equally readopt the claimant's final written address, which was filed on the 31st day of May 2022, as our oral argument in urging my lord with respect to grant the reliefs of the claimants. We are most grateful, sir.
Very well. Here's the judgment of a court.
Let's go, please.
It is the claimant's case be the statement of material facts that he is an employee of a defendant and was later confirmed as a staff. He averred that after some changes and privatization of PSCN by the federal government, the defendant absorbed him and offered him a 6-month contract of employment, which was renewed on the 5th of May 2014. He continued that on the 3rd of November 2014, he was given another letter of employment by Adoy Limited and was renewed on 28th of October 2016 by the same company. He stated further that in another development, he was given another letter of appointment by the second defendant through the first defendant and has been in service of the first defendant for a period of 17 years. He stated that he has also been making his contribution to the National Contribution Pension Scheme for a period of 17 years. He contended that he was not given any query or suspension, neither did he face any disciplinary panel to answer any allegations, but the second defendant withheld his salary since May 2019 till date, which is clearly a breach of the guideline of the defendant. He stressed that all efforts to get the defendant to solve the issue by a complaint letter was to no avail, as a result of which he instructed his solicitor to take legal steps. It is against this backdrop that the claimant, by a writ of summons dated 14 January 2020, filed this suit against the defendants, seeking the following reliefs. 1, a declaration that withholding the claimant's salary from May 2019 to date without any just cause is unlawful and a breach of the terms of their contract of employment. B, a declaration that the claimant is entitled to his salary for the period he worked for the defendant. C, a declaration that the continued withholding and or refusal of the defendant to pay the claimant his salary is a gross violation of the claimant's right to enjoy his salary he has worked for. D, an order compelling and directing the defendants to pay arrears of salaries owed the claimant as follows. 1, full month salary in the sum of 89,000 naira from March 2019 until final determination of this case and hence this action. 2, the contribution of a claimant contributed to the National Contributory Pension Scheme for a period of 17 years now, which is in the sum of 1,881,029 naira 24 kobo, as at the time of filing these actions, since the claimant can only get this contribution back through the first and second defendants. E, an order prohibiting or restraining the defendants from taking any further decisions or acting in any manner or doing anything whatsoever that may adversely affect or prejudice the claimant. F, the sum of 2 million naira as general damages for physiological trauma the claimant went through against the defendant. G, the sum of 20 million naira as general damages for psychological trauma, physiological trauma the claimant went through against the second defendant. H, cost of this action, and I is an omnibus prayer. First defendant in his statement of defense denies each and every allegation of the facts contained in claimant's statement. It asserted that there is no contractual relationship whatsoever between the claimant and the first defendant. To continue that the claimant was only an employer for an employee for a period of 2013 and ceased 2013 and ceased in 2014, and that the contractual relationship elapsed at the expiration of 6 months and was renewed for another 6 months, but came to an end in November 2014. It asserted that the claimant clearly admitted that he was an employee of Adoy Limited and the second defendant preceding this action, and that its operations and business are distinct from the Adoy Limited and the second defendant. It continued that it is not a proper party to the contractual relationship that exists between the claimant and the second defendant. It is in the first defendant's contention. It is also the first defendant's contention that it is impossible that the claimant was in its employment for 17 years and as important, it was not a legal entity for 17 years. It is the further position of the first defendant that its company is not the management, custodian, or administrator of the National Contributing Pension Scheme, to which the claimant claimed he made contributions for 17 years. It asserted that it is not privy to any contractual relationship between the claimant and the second defendant. It urged the court to dismiss the suit against it. The second defendant, in its response, via its statement of defense, asserted that they deny each and every allegation contained in the claimant's statement of claim. It continued to assert that the claimant was an employee of the second defendant who was deployed to the first defendant as a fire protection officer, and that the claimant was only engaged with the second defendant under the contract of employment for a term of 1 year. He stated that the claimant does not have any relationship with any person, pension administration. Sorry, that the defendant does not have any relationship with any pension administration. It asserted that the claimant and one Simpa Shehu was seen via a CCTV camera within the first defendant complex, making away with condensate, a natural gas product, and that consequent upon the discovery of the theft, a panel was constituted to investigate and afford all the persons involved to defend themselves. It asserted that both the claimant and the said Simpa Shehu attended the panel separately, whereof they were found guilty and concluded not to press charges, but terminated their employment without payment in lieu of 1 month notice. It went on to assert that both the claimant and Simpa Shehu was assured that they will be paid their outstanding salaries and allowances upon the release of their identity card issued to them at the time of their employment. That Simpa Shehu complied and was paid his salaries, while the former, that is the claimant, failed to or refused to hand his over. It was stressed that the claimant neither wrote any letter to it, as they were not aware of any such complaint, and that there is no basis in contract of employment between the claimant and the second defendant that entitles him to salaries from the month of May 2019 till the date. Thereof, claimant is also not entitled to the relief sought for. The second defendant, by way of a counterclaim, alleged that the claimant defendant to counterclaim was seen via the CCTV camera making away with 750 liters of condensate, a natural gas plant within the first defendant's complex, and that it was against the background of theft committed by the defendant to counterclaim and his admission of the allegation against him after he was confronted with the clip at the hearing of the panel setup that his employment was terminated by the second defendant without payment of salary in lieu of notice. The counterclaim states counterclaimant states that the value of 750 liters of condensate stolen is 3,450,000 naira. Therefore, it shall be contended at the trial that it is entitled to withhold the outstanding salaries of the defendant to counterclaimant and any other sum due to the defendant to counterclaim until he hands over the property of the company in his possession, as well as the 750 liters of condensate stolen from the first defendant. It is against this backdrop that the defendants counterclaimants are claiming the following against the claimant defendant to the counterclaim. A declaration that the employment of a defendant to counterclaim with the counterclaimant has been terminated by the notice of termination of contract dated 2nd July 2019. B, a declaration that the defendant to the counterclaim is not entitled to his outstanding salary of 2 months of May and June 2019, or whichever sum he is entitled from the counterclaimant upon the cessation of his employment on the 1st of July 2019, until he properly hands over and deliver all the properties given to him by virtue of his employment with the counterclaimant, particularly the Geregupa PLC identity card he retains after the cessation of his employment. E, a declaration that the defendant to the counterclaim is indebted to the counterclaimant in the sum of 3,450,000 naira, being the value of 750 liters of condensate stolen by the defendant to the counterclaim at the Geregu Power Plant Station, where he was posted by the counterclaimant. And the alternative to relief C, D, a declaration that the defendant to the counterclaim is liable to return 750 liters of the condensate he carted away from the Geregu Power Plant Station, where he was posted by the counterclaimant. E, a declaration that the counterclaimant is entitled to net off the outstanding salaries of 2 months of May and June 2019, or whichever sum the defendant to the counterclaim is entitled from the counterclaimant upon the cessation of his employment on the 1st July 2019 to defray the sum of 3,450,000 naira, being the value of the 750 liters of condensate stolen by the defendant to the counterclaimant at the Geregu Power Plant Station. F, an order of the Honorable Court directing the defendant to the counterclaim to properly hand over and deliver to Geregu Power PLC identity card issued to him by virtue of his employment with the counterclaimant. G, an order of the court directing the defendant to the counterclaim to pay the sum of 3,450,000 naira, being the value of 750 liters of condensate stolen by the defendant to counterclaim at the Geregu Power Plant Station, where he was posted by the counterclaimant, or whichever sum is outstanding after the 2 months' salaries for the months of May and June 2019 is net off from the aforesaid value of the 750 liters of condensate stolen by the defendant to the counterclaimant, to the counterclaim. And also in the alternative to relief F, H, and order of the Honorable Court directing the defendant to the counterclaim to deliver 750 liters of the condensate is sold at Geregu Plant Station, where he was posted by the counterclaimant. I, the cost of this action assessed at 500,000 naira. The claimant replied to the second defendant's statement of defense and defense to the counterclaim, wherein averred that it is a general policy applicable to the second defendant that his employee will contribute certain percentage and also an employer monthly basic salary to the National Contribution Pension Scheme, Contributory Pension Scheme. Now, the claimant is entitled to claim his contribution through the second defendant. Claimant continued that he did not commit any theft and was not shown any CCTV camera of him committing any theft, neither was any panel set up, nor was any query or was he suspended. He averred that he was not given any termination letter either, as he has continued working for the second defendant. Instead, he was denied his entitlement. He stated that the complaint he made has to be made through the first defendant, and the first defendant is supposed to have informed the second defendant. He then averred that the second defendant held on to his entitlement with no just cause. He stated that he is not indebted to the second defendant for the value of 750 liters of condensate or any amount, and did not steal same. Thereof, he puts the second defendant to the disputed proof of same. Also filed with the first defendant's statement of defense, the notice of preliminary objection, which this court has ruled will be taken together with the main suit. The third notice of preliminary objection is praying the court to strike out the suit for being grossly incompetent on the following grounds. A, that the claimant initiated this action by filing a writ of summons dated 6 January 2022, as well as a statement of claim at the registry of this honorable court The originating processes filed by the claimant are unknown and completely alien to the rules of this honorable court. B, the prescribed mode of commencement of an action in this court as stipulated by the rules of the court were contravened by the claimant, thereby rendering this action incompetent as presently constituted. The defect in the originating processes further tainted the amended originating processes filed by the claimant pursuant to the order of this court made on the 1st of July 2021. C, the purported amended originating processes and pleading filed by the claimant did not also indicate that the processes were amended pursuant to the order of the honorable court as prescribed by order 26 rule 8 of the rules of the court. D, the entirety of the processes filed by the claimant constitute an embarrassment to the first defendant as it discloses no reasonable cause of action against the first defendant. Claimant, by its amended writ of summons filed on 12 July 2021, is seeking in the main a declaration that withholding the claimant's salary by the second defendant from May 2019 to date without any just cause is unlawful and a breach of the terms of their contract of employment. E, there is no document concluded by the claimant showing any contractual relationship in existence between the claimant and the first defendant as of 2019 when the cause of action in this suit arose. F, a reasonable cause of action must set out the claimant's legal right and the defendant's allegedly ignored obligations stated in clear terms. The claimant's pleadings and front-loaded documents have not validly established any subsisting right of the claimant which was infringed upon or breached by the first defendant. And G, the claimant's action as presently constituted cannot by any ingenuity be sustained against the first defendant, as the first defendant is neither a proper party nor necessary party to this suit. This honorable court is empowered to strike out the name of the first defendant from this suit. Accompanying the notice of preliminary objection, it's a 16-paragraph affidavit and written address. I've reduced the written address into the body of this judgment. And the claimant equally filed a reply on point of law. I've reduced that also into into this judgment. Parties equally filed their final written addresses, which has also been reduced into the body of this judgment. So I will now go straight to the decision of the court. I've perused the processes filed in this case, together with all other documents and the submissions of all counsel. It is in my humble view that the three germane issues, the determination of which will meet the justice of this case are: A, whether this court is vested with jurisdiction to entertain this case, and if this is answered in the affirmative; B, whether claimant is entitled to the relief sought; and C, whether the second defendant's counterclaimant has proven its entitlement to save. It is germane for me to address the notice of preliminary objection raised by the first defendant at the outset before going into the merit of the case. The first grounds of the first defendant is in respect of some documents tendered by the claimant, either exhibits L, L1, L2, and L3, as well as L10. According to learned First Defense Counsel, these documents relating to claimant's employment are not admissible because to him, they have no nexus to the facts in issue. Placing reliance on the case of Abo and Ayan Supra, she captured the decision of the appeal court in that case, wherein a document is said to be admissible if it is pleaded or facts relating to it are pleaded. The document should be relevant, and finally, that the document should be admissible in law. Counsel concluded by stating that all the documents seeking to establish claimant's employment history is irrelevant, and thus the court should hold that they are inadmissible. It is a further contention of learned defense counsel that Exhibit L10, being a computer-generated document, has failed to comply with the provision of Section 84 of the Evidence Act. In his response, the learned claimant's counsel argued that the documents were pleaded at paragraphs 5 to 12 of his statement of facts, and that the document seeks to establish claimant's relationship with the first defendant, and thus should be held to be admissible in evidence. A cardinal consideration in admissibility of documents is relevancy. The law is long settled that relevancy is a precursor to admissibility. An irrelevant document is admissible, is inadmissible in evidence. See the case of Muleye and Aino in all the citation captured and sections 1, 2 of the Evidence Act 2011. Now by section 4 of the Evidence Act and same given a judicial nod in the case of Agbo and in another and Nwoye and others citation captured, whereby the court held while quoting section 4 of the Evidence Act states that facts though not in issue, which are connected to the facts in issue as to form part of the same transaction are relevant, whether they occurred at the same time, place, or at different times and places. I've carefully perused exhibits L, L1, L2, and L3. They are claimants' letters of appointment, confirmation of appointment by PSCN, his posting to Geregu Power Station, that is the first defendant, another letter of appointment when PSCN was unbundled as a means of record by Adoy Limited to work with the first defendant between 2014 to April 2015. There's another letter dated 5th May 2014 issued by the first defendant to the claimant renewing his contract of appointment from 1st May 2014. Exhibit L3 is a promotion letter. I found facts relating to the claimant's employment history at paragraphs 5, 6, 7, 8, 9, 10, and 11 of the claimant's amended statement of claim. It is in the light of all these averment are those paragraphs of the claimant's pleadings as well as the documents themselves, which speak for themselves, that I find and hold that exhibits L, L1, L2, and L3 are relevant in evidence. They have nexus and connections to the claimant and the first defendant and are thus admissible in evidence. The first defendant's argument that the documents are mere history of claimant's employment, which has no connection to the main issue before the court and should thus be held to be inadmissible and misconceived. I say this in view of the fact that first, the first defendant is contesting that it has no employment relationship with the claimant. Secondly, a claim for payment of salaries cannot be sustained without evidence of employment relationship. At the same time, payment of salary cannot arise without a contract of employment relationship, except if the first defendant is asserting that monies paid to the claimant as salaries were merely paid to him on charitable ground or as a Father Christmas, or that the letter of employment contract is issued to the claimant on the 5th of May 2014 on its letterheaded paper was conjured by the claimant. It is in consequence of all said detail, the content and tenor of those documents, that I find and hold that exhibits L, L1, L2, and L3 are all relevant to the facts in issue and are thus admissible in evidence. Accordingly, exhibits L, L1, L2, and L3 stand admitted and still forms part of the record of this court. Now respecting exhibit L10, which constitutes claimant's pension registration certificate from IBTC pension. It equally shows the statement of his pension and his account as at 20th of April 2021. Exhibit L10 on record, if it has any relevancy in this case at all, is when it means that the first and second defendants have lived up to their statutory obligation to the claimant by remitting their pension contribution to the claimant's PFA. That, in my humble view, is a plus to the defendants. The document, according to the claimant, was retrieved from his account domiciled with his PFA. Thus, pursuant to Section 12(2)(b) of the National Industry Portal Act 2006, which empowers this court to depart from the strict provision of the Evidence Act in the interest of justice, that I so depart from the provision of Section 84 of the Evidence Act and therefore hold that exhibit L10 being a relevant document is thus admissible and accordingly stands admitted in evidence. It is from the foregoing that I hold that the first defendant's objection to these documents is unmeritorious and thus discountenanced. The other arm of the first defendant objection is that the originating processes filed by the claimants are unknown and completely alien to the rules of this court, and that the claimant's case discloses no reasonable cause of action against the first defendant. The claimant filed his counter affidavit to same, wherein he averred that he worked in the first defendant premises and uses its identity card at all material time before instituting this action. As such, his relationship with the first defendant subsists and give rise to his cause of action against the first defendant. To the first objection of first defendant in his preliminary objection filed on the 6th of August 2021 is that the originating processes filed by the claimants are unknown and completely alien to the rules of this court. Grounds 1, 2, and 3 of the objection hinge on the processes filed by the claimant, and to the first defendant, they fall short of the rules of this court and thus incompetent due to the amendment made thereto. According to Learned Defense Counsel, the title to the originating processes should be general form of complaint as stipulated by 2017 rules of this court and not quote and unquote writ of summons. It is correct to say that by all the three of the rules of this court, a form of commencement of an action in this court may be one of 7 ways listed in Rule 1 of all the 3. It may be by complaint, originating summons, originating motions, application for judicial review, notice of appeal or petition, referral from the Minister of Labor and Productivity, and by any other means that may be prescribed by the rules, act, or any law in force in Nigeria. It is evident on record that quote and unquote writ of summons is a form of commencement of action recognized by law in Nigeria. This is the title of the originating processes known as the High Court of FCT, High Court of State High Courts, and the Federal High Court. It is also the position of NIC Rules 2017 that the rules of any state high court may be applicable to the rules of this court. In other words, since quote and unquote writ of summons and statement of claim are known as originating processes in the high court, they can be applicable and be recognized by this court as a means of commencement of an action. It is equally clear by Order 5, Rule 1 of the same rules of this court, 2017, which urges the court to regard or treat a non-compliance with its rules as a mere irregularity. It provides those, and I quote, Order 5, Rule 1, quote, failure to comply with any of these rules may be treated as an irregularity, and the court may give any direction as it thinks fit, unquote. The rules of this court is in sync with the type of cases that the court handles, giving room for flexibility of its procedure. Hence, Order 5, Rule 6, Sub-Rule 3 provides those, and I quote, in any proceeding before this court, the court shall apply fair and flexible procedure and shall not allow mere technicalities to becloud doing justice to the parties based on the law, equity, and fairness, while also considering the facts of any matter before it, unquote. It is obvious that the objection of the first defendant hearing is a procedural competence for initiating the suit, which falls within the precinct of the court's adjectival laws. It has been held as semi-settled law that non-compliance with procedural requirements for initiating an action by itself and irregularity in the exercise of jurisdiction should not be confused with total lack of jurisdiction. I must equally state that procedural jurisdiction may be waived. See the case of Ostan Kino Shipping Company Limited and the owners, MT Bata, citation captured. The case of Bakari and Idigbe, citation also captured. I find that the writ of someone's title, the originating process in this case, is in general context also a means of commencement of an action by an aggrieved party. To yield to the argument of the first defendant is to push the court backwards into the dark days of technical justice, which the court has since moved away from. See the cases of Aeronautical Engineering and Technical Services Limited and North Wales Military Aviation Services Limited citation captured, and the case of Adamu and the state citation was also captured. Therefore, I find the use of the words quote and unquote writ of summons and statement of claim as mere semantics and a procedural defect, being equally a means of commencement of action as in general form of complaint and statement of fact, as they are being called in this court. It should also be stated here that this court, as a superior court of record, can exercise and have all the powers of a high court. See section 254D, subsection 1 of the Constitution of Nigeria 1999 as amended, and section 1, sub 3B of the National Industrial Court Act 2006. It is therefore without any equivocation that first, I depart from the strict rules of this court in the overall interest of justice of this case, and find that the use of the words quote and unquote writ of summons and statement of claim in the originating processes ditto the amended statement of facts, and find that they are mere procedural irregularities, and hold that the writ of summons, statement of claim, and the amended statement of claim are competent as they are recognized as a means of commencing an action. They are thus competent, I thus find and so hold. Assuming that the non-filing of a general form of complaint is wrong as argued by the first defendant and thus incompetent. In the recent Supreme Court decision, the case of Sholumade and Kuti, citation captured, the Apex Court per agim GSC, while considering the yardstick for the validity of the originating process, held entirely outdoors, and I quote him. The writ of summons had already been signed, sealed, and issued by the Registrar of the Trial Court on the 5th of October, 1998. After the plaintiff application in Form 1, the writ was presented in the Registry of the Trial Court for filing, and the filing fees assessed by the registrar paid. The writ of summons became a valid legal originating process once it was filed, signed, and sealed and issued by the registrar. Once the Registrar of the Trial Court accepted the plaintiff's application in Form 1 for the filing and issuance of the writ of summons, filed and issued it, in spite of any defects in the application Form 1, a valid writ of summons comes into existence. The registrar has the prerogative power to refuse to accept for filing a writ of summons because of omissions or other defects in the Form 1 in which the application is made. But once he or she accepts it for filing, files, and issues same, the writ of summons becomes legally effective, unquote. Following the decision of the Apex Court in the above case, it is obvious that once the writ of summons has been accepted for filing by the Registrar of Court, notwithstanding any omission or defects, appropriate filing fees paid, and same was signed and issued by the registrar, the writ becomes a valid legal document. In the instant case, although as stated supra, the process was titled writ of summons and statement of claim presented for filing at the registry of this court, it is a prerogative of the court registrar to reject same due to or the inappropriate title. But once it was accepted by him for filing, despite the wrong title, and same was assessed and the appropriate filing fees was paid, as seen at page 36 of the record of this court, and which process was signed, dated, filed, and issued by the registrar of this court on the 14th of January 2020, the writ of summons and statement of claim becomes a legally valid, competent, and subsisting process in this case. I so find and hold. Next is the issue of whether or not this suit discloses a cause of action against the first defendant. To the first defendant, the claimant's case has not disclosed any cause of action against it, and thus its name should be struck off the suit. It went on to state that there is no complaint against the first defendant by the claimant in this case. The claimant on its own part, argued that paragraphs 4 to 16 of the affidavit in support of preliminary objection offends section 115 subsection 2 of the Evidence Act, in that there are legal arguments and conclusions. That the issue that he has no cause of action or complaint against the first defendant is an afterthought. That paragraph 8 of his statement of claim and paragraph 10 of the second defendant's statement of defense show that the claimant has a cause of action against the first defendant. Now, section 1152 of the Evidence Act provides those, and I quote, an affidavit shall not contain extraneous matter by way of objection or prayer or legal argument or conclusion, unquote. It is true that paragraphs 4 to 16 of the affidavit in support of the first defendant's preliminary objection offend section 115 of the Evidence Act. I peruse paragraphs 4 to 16 of the affidavit, and I find it apparent that the deponent, Aliyu Al-Hassan, went on to town by arguing the case of the first defendant with titles like quote and unquote failure to comply with the extant rules of court ahead of paragraphs 4 to 8. There's another title it gave a heading, quote, absence of cause of action against the first defendant, unquote, with legal arguments and conclusions. It is thus clear from the affidavit of Aliyu Al-Hassan that the offense, section 115, subsection 2 of the Evidence Act. Consequently, paragraphs 4 to 16 of the affidavit in support of preliminary objection are hereby struck out. The effect of this is that the only paragraph left are paragraphs 1 to 3, which are introductory part of the affidavit, and that makes the affidavit one without substance or fact and thus worthless. The same fate befalls the further affidavit filed by the first defendant on the 28th of June 2021. Now, it is a self-evident truth, as same is rooted in law, that the law does not hang, as it were, in the air. Facts are the fountainhead of the law. So every proposition of law has a factual base. Therefore, whereas in this case, the facts upon which the first defendant rests his objection is no more, then the whole basis of the objection must crumble. Having held that there is no substance in the affidavit, will it be right to hold that the preliminary objection is sustainable? I find that there is no facts linking the objection to the grounds raised in the preliminary objection. The consequence of this is that the objection has no foundation to stand on and will thus collapse. As the law is long settled that you cannot place something on nothing and expect it to stand, see the case of UAC and McCoy, which says so, and concluded that it shall surely fall, and concludes that it shall surely fall. Assuming, but I'm not conceding to the fact that there is a competent affidavit for the court, there is need to consider the second arm of the first defendant's objection, which is to the effect that the claimant has not disclosed any cause of action against the first defendant. The claimant submitted that his case has established a cause of action or complaint against the first defendant. It is germane for me to start by asking the question, what is the cause of action? I will be content in this respect to adopt the definition of the expression by Diplock LJ in an age-long English case of Litang and Cooper, citation captured, where he defined it as, quote, a simple, a factual situation, the existence of which entitles one person to obtain from the court remedy against another person, unquote. Let me now come back home and consider the position of the court in Nigeria per Fatai Williams DSC of blessed memory. In the case of Savage and Owechia, citation captured, where he reasoned that, quote, a cause of action is defined in Stroud's Judicial Dictionary as the entire set of circumstances giving rise to an enforceable claim. To our mind, it is in effect the fact or combination of facts which gives rise to a right to sue, and it consists of two elements, the wrongful act of the defendant, which gives the plaintiffs his cause of complaint, and the consequent damage, unquote. See also the recent case of Alaafin and Wakala and others, the 2020 decision of the Court of Appeal. Apparently, from the above definitions, the principal elements of these definitions are that it involves two persons, one of whom has the right to a judgment against the other. The other element is that it is a factual situation. The factual situation could be revealed in the statement of claim. I've taken note of paragraphs 1, 2, 3, 10, and 11 of the claimant's statement of claim, which are facts linking the first defendant to this suit. Those paragraphs means that the first defendant has a contractual relationship with him, as well as the second defendant. I would not want to go into the merit of this case at this plenary stage. Hence, all that is obvious by the pleadings of the claimant is that he has a grievance against the first defendant, with whom he had always worked. It is therefore, in my respectful view, that the claimant's case has established a cause of action against the first defendant. In this case, I so find and hold. Now to issue 2, which is the merit of this case. It is the first defendant's position that he has no employment relationship as that stated even in its its preliminary objection. In other words, it does not know the claimant. It is therefore germane to consider if there exists any relationship between the claimant and the first defendant. I find from paragraph 5 of the claimant's statement of claim and exhibits herein attached to prove his relationship with the defendants that the claimant was first appointed on 26th of August 2002 by PHCN, confirmed as a staff of the company with effect from 9th September 2002, and on the 13th of October 2010, he was posted to Geregu Power Station, that is the first defendant's office. Following the privatization of the power sector, he was placed on the 6-month contract from November 2013 by the first defendant, and the contract was renewed afterwards up until November 2014 by exhibits L2 and L4. I also find from the claimant's statement of claim and exhibit before the court that subsequently the claimant was hired to work on a renewable 6-month contract for the first defendant through another company called Adoy Limited, with a letter of contract dated November 3rd, 2014 and 28 October 2016. And he was also engaged through the second defendant to continue his engagement with the first defendant for a 12-month contract by a letter dated 14 January 2019. The first defendant, on the other hand, only admitted to being in a renewable 6-month contract with the claimant from November 2013 to November 2014. The second defendant admits his relationship with the claimant only to the extent that the claimant was issued a term of contract of employment dated 14 January 2019 under a one-year contract from 1st January 2019 to 31st December 2019. It is obvious from the above admission and the exhibit on record that there is some sort of arrangement between the claimant and the defendants. This type of arrangement is recognized in labor jurisprudence as a tripartite arrangement, that is, a relationship where a person called labor contractor recruits personnel and deploys them to client company or end user on a needs basis. By this arrangement, there is usually a contract of employment between the deployed employee or employees on the one hand and the labor contractor on the other hand. However, no such contractual relationship is intended to exist between the employees and the company. The ILO calls this a disguised or objectively ambiguous employment relationship, which is meant to either mask the identity of employer, where the person designated as employer is an intermediary with the intention of releasing the real employer from any involvement in the employment relationship, and above all, from any responsibility to the workers or staff, or mask the form in which the relationship is established, as where the nature of the employment relationship is intentionally misrepresented so as to deny certain rights and benefits to the dependent workers. This type of employment relationship is recognized by our own Labor Act, specifically Section 91 of the Labor Act, Cap L1, Laws of the Federation of Nigeria, 2004, which defines who an employer is, thus, and I quote, any person who has entered into a contract of employment to employ any other person as a worker, either for himself or for the service of any other person, and includes the agent, manager, or factor of that first mentioned person and the personnel representative of a deceased employer, unquote. The import of this is that an outsourced company, as they are being called, is recognized by law as an employer within the ambit of our labor jurisprudence. Now, in relation to this instance suit, and from the exhibit put forward by the claimant to prove its case, the first defendant has appeared in every contract between the claimant and Adoy Limited and between the claimant and the second defendant. DW1 on record equally stated on record that the second defendant outsourced staff to the first defendant and that claimant is one of the staff. It is thus not in dispute that the first defendant had a direct contractual agreement with the claimant sometimes from November 2013 to November 2014. The arrangement between the Adoy Limited, the first defendant, and the claimant, same as the second defendant, is one that is called a tripartite arrangement as stated supra, as enjoined by the ILO. The National Industrial Court, that is, this court, is guided by the principle of primacy of facts in the determination of the existence of an employment relationship, that is, in determining whether there is an employment relationship between different parties, as in this instance. The court is guided by the fact of what was actually agreed and performed by the parties and not by the name the parties gave to the contract. In the instance suit, the second defendant contract of agreement with the claimant dated 14 January 2019 explicitly stated thus, and I quote, we refer to previous discussion with you on contract employment with Boomtak Gold Concept Limited. We are pleased to offer you a 12-month fixed-term contract employment from the 1st January 2019 to 31st December 2019. During the period, you will work with our client, Geregu Power Plant, to be known as the company, as a fire protection officer. You will initially be located in Geregu. The company may require you to be posted to any other location in the nearest future, but this will be done with adequate notice to you, unquote. It is evident from the above that what was agreed by the claimant in the contract between the second defendant and claimant is that the claimant will be working for the first defendant as a fire protection officer. It is settled principle of our law that where the court is called upon to make a declaration of a right, it is incumbent on the party claiming to be entitled to the declaration satisfy the court by preponderance of evidence, not by admission in the pleadings of the defendant that is entitled to same. The necessity for this arises from the fact that the court has a discretion to grant or refuse the declaration, and the sources of the claimant in such an action depends entirely on the strength of his own case and not on the weakness of the defense. See the case of Odera Investment Company Limited and EcoBank Nigeria PLC, citation captured. The case of that PE and another versus Musa and other citation provided. The case of Okonjo and Nwakoni, citation also captured. The claimant herein, via the exhibit placed before this court, has been able to prove to the court that there exists a tripartite employment relationship amongst himself, the first and second defendants. I so find and hold. Next is issue 2 framed above. The claimant by its relief, this continuation of relief of issue 2. The claimant by his reliefs 1 and 2 is praying the court for, just a minute, is praying the court for his salary, that the withholding of his salary by the second defendant from May 2019 to date without any just cause is unlawful, and a breach of the terms of their contract, and that the court should declare that he's entitled to his salary for the period he worked for the defendants. Claimant submitted that he was neither given any query or suspended nor faced any panel to answer any allegation. He also asserted that his contract with the second defendant was not terminated and that his salary was withheld by the second defendant without any just cause. The first defendant ordered the court to dismiss reliefs 1 and 2 against it because the claimant has failed to substantiate these claims against it. On its own part, the second defendant contends that Exhibit L6, being the bedrock of the relationship binding between them, should be interpreted by the court. The defense went on to allege that it terminated claimant's employment via Exhibit J, which according to counsel was in compliance with clause 2.9 of Exhibit L6. Noteworthy is the fact that Exhibit L6 is a contract of employment issued by the second defendant to the claimant, engaging him to work with the first defendant from 1st January 2019 to December 2019. It evinces that the claimant will work at the first defendant employ on an annual salary of 1,141,494 naira 8 kobo and a 13-month salary payable in November. The law is that where the terms of contract are in writing, parties are bound by the express terms of their contract. The duty of the court in such instance is to interpret the terms of contract of parties and give effect to it. See also the case of Omega Bank PLC versus OBC Limited, citation captured. The court, in interpreting the terms of the contract between parties, must give the words their plain, ordinary, and natural meaning, where the words used are clear and unambiguous. It is plain on Exhibit L6 that there exists an employment relationship amongst the trio held supra to be a tripartite employment relationship. DW2 on record admitted that the second defendant is owing claimant salary and that he was assured that he and his colleague will be paid their outstanding salaries and allowances upon they duly handing over their identity card issued to them. That the reason why claimant has not been paid is because he failed or refused to hand his identity card over. Also, he asserted that the claimant and one Simpashe were seen via the CCTV camera within the first defendant's complex, making away with condensate, a natural gas product, and that consequent upon the discovery of the theft, a panel was constituted to investigate and afford all the persons involved to defend themselves. He went on that both the claimant and Simpashe attended the panel separately, whereof they were found guilty and concluded not to press charges, but terminated their employment without payment in lieu of 1 month notice, and the letter of termination was dispatched to the claimant. It is obvious on record that the claimant is being owed salary from May 2019 as admitted by the second defendant and evinced on record. However, the contention of the second defendant for withholding his salary is because of the allegation of theft against him and one Simpa. Now, the law in employment and labor relations is that in a master-servant employment of this present, the master may fire the employee without any reason, but where the employer gives reason either expressly or as could be gleaned from their pleadings, as in this instance suit, the second defendant will have to justify the reason. See the case of Ingwe Chi and Union Bank, citation captured, the case of LH, ABU, HMB versus Kanyip, citation provided. More so, where an allegation of misconduct is committed in an employment, the first question to ask is, was the claimant heard and given a right of fair hearing? where it is proved that a party was not accorded or given opportunity to defend himself before a tribunal, a panel, or an ad hoc committee or a quasi-criminal panel, the case will be rendered a nullity and will be vacated and set aside forthwith. See the case of Nicholas Chukwu, Jeku, Ukachukwu, and PDP and others, citation captured. Defendant who wants the court to believe that the claimant committed the theft has the burden to prove beyond doubt, more so as it is a criminal offense. He is required to specifically plead the particulars of the offense and beyond reasonable doubt with credible and verifiable evidence that, in fact, claimant stole the condensate. See the case of Talek Drugs Company Limited and Onankwa citation captured, the case of Biko Nigeria Limited and another versus Electronic Connections Limited citation provided. It is of note that claimant was not given a query to answer to the allegation against him. The second defendant asserted that claimant and one Simpashewu were invited to a disciplinary committee to answer to the charges. I found no single evidence on record to prove that there was any committee investigation, let alone the alleged admission to the crime by the claimant. The second defendant did not produce any document to substantiate its claim. DW1 under cross-examination answered thus, and I quote, "The proceeding of the investigation was in written form, but I do not have it in court." Question, did you serve a report or a query on the claimant? Answer, we did not. Question, after the incident, the claimant worked for the first defendant for 2 months before he went on leave, and he answered yes, unquote. It is plain from the above evidence of DW that no query was served on the claimant or the report of the alleged panel was not produced in court. And the report of the panel was not produced in court. They equally had opportunity to call the said Simpashewu to corroborate the testimony of DW1, but refused to call him, and there was no reason for its failure. The second defendant equally tendered a CCTV recording purportedly as the evidence of the theft. I find from watching the video that there were 2 people drawing something from one part of the premises to another. There was no evidence from watching the recording to prove that the claimant took it away from the present premises of the first defendant and sold it as alleged by the second defendant. DW2 was told about the incident. He does not know how the claimant or Simpashe would look. He stated also that they did not report the incident to the police. He will not equally know the number of people involved in the incident. As stated earlier in this judgment, the allegation being a criminal one has placed a heavy onus on the second defendant to prove the allegation of crime against him. There's equally no iota of evidence on record to show that the case of theft was reported to the police. It was investigated and conducted, investigation conducted, and they made a finding that claimant committed a crime of theft of the condensate. The defendants could not explain to the court why criminal allegation of theft was not reported to the police, and the claimant was also allowed to stay in office and work for the first defendant for 2 more months after the incident of the alleged theft. It is in my finding from all the foregoing evidence on record that the allegation of theft of the condensate is an afterthought. It is a barefaced savings scheme or cooked up sham by the second defendant to withhold claimant's salary owed. It is in consequence that I discounted as the contention of the defendants as being frivolous and unfounded, and that the second defendant failed to justify the reason for withholding claimant's salary. I so hold. The second defendant also asserts in his pleading that it terminated the contract of employment of the claimant on the 4th of July 2019 by dispatching a letter of termination Exhibit J to his address. The claimant, on the other hand, denied receipt of the purported termination letter. It is tried law that constructive knowledge of termination or dismissal does not suffice in the absence of a letter of notification to that effect. The law equally frowns at unilateral termination of contract without the knowledge of the other party. Where there is no communication, the whole essence of the message is completely defeated. See the case of PACN and Ofoilu citation capture, the case of Advanced Maritime Transport Nigeria Limited, and Oju, Goli, and other citation captured. In the same vein, an employee cannot be deemed to have knowledge or notice of his or disengagement or dismissal until he has been properly or expressly notified. The correct view of the law is that an employment contract is brought to an end by a dismissal or termination letter sent by or on behalf of the employer to the employee as his or her last known address and delivered to that address, and it comes to an end on the date of such delivery, regardless of whether or not the employee was there at the time or later on that day or did not see the letter. In essence, the service of the letter at the last known address of the employee must be confirmed. See the English case of Gizda CYE versus Barat, citation captured. It is therefore right to say that the effective date of termination of the claimant's contract will be determined by the exact date on which the letter was delivered to the claimant and not the date on which the letter was written. I in-depthly examined the attached courier way bill attached to the purported letter of termination, that is SBJ, and it is in my finding that the letter was received by DHL Courier Service on the 4th of July 2019 from one Akindele Ojo of Geregu Power Plant PLC, the first defendant. It was addressed to the claimant to be delivered to his address at Tungamaji area, Zuba, Abuja. First, it is noteworthy that the address for service did not specify the house number or street name of the address for service. It is a notorious fact that to state an unspecified address without street name or house number, but only provided the area address, would make it very impossible for the courier service to locate the address. No wonder there is no indication on the waybill that the letter of termination was delivered at the address provided by the defendants. The defendants have therefore failed to substantiate their claim that the letter of termination was delivered at the last known address of the claimant. By the case of Gizda Supra, by merely sending the letter by mail without more does not absolve the defendants for proving that they did in fact serve the letter or deliver this letter at the claimant's last known address. It is in the light of this that I find it reasonable to believe the claimant's assertion that it was never served with any letter of termination. Accordingly, I hold that claimant's employment was not terminated by SBJ. Although I found that the second defendant who gave reasons for termination of the claimant's employment did not justify its reason before the court, it is however obvious from the actions and inactions of the defendants that they do no longer want the claimant in their employment and the relationship has gone sour. It is equally true that the court cannot force a willing employee on an unwilling employer. In view of the fact and circumstances of this case, the court is of the view that the employment relationship amongst parties have been constructively terminated. This, however, means that the claimant's contract is said to have come to an end on July 2019 when the claim, this, however, does not mean that the claimant's contract is said to have come to, could be said to have come to an end since July 2019. Next, claimant in his reliefs A and B is claiming for his salary from May 2019 up until date in the absence of a valid termination. It is not in dispute that the second defendant admits to owing the claimant his outstanding salary, but only for May and June 2019. I've earlier found that the claimant's contract with the second defendant is constructively terminated. I therefore find that claimant's reliefs A and B succeed only to the extent that the withholding of his salary, May and June salary to date is wrongful, and thus it is in my humble view that the claimant is entitled to payment of his salaries for the months of May and June 2019. I so find and hold. Claimant in his relief C is asking that the continued withholding or refusal of the second defendant to pay him his salary is a gross violation of to enjoy his salary he has worked for. It is the second defendant's contention that it fails to pay the claimant his salary because he failed to submit the ID card of the first defendant. The defendants failed to prove that they requested him to hand over his ID card. The law by Section 15 of the Labor Act provides that wages or salaries shall become due and payable at the end of each period for which the contract is expressed to subsist, that is, daily, weekly, or at such other period as may be agreed upon, provided that where the period is more than 1 month, the wages, salaries shall become due and payable at intervals not exceeding 1 month. See the case of Sali Udele and Ajaokuta Steel Company and another is an unreported suit of this court. Suit number NICN/LKJ/15/2019. Judgment delivered on 28th of October 2021. And in the case of Mr. Sule O. Usman and Union Bank of Nigeria PLC, is also an unreported suit number NICN/LA/56/2012. Judgment delivered on 21st of May 2014, wherein it was held that employer's action of non-payment of salary of the worker as and when due was contrary to Nigeria's international obligation under the ILO Convention and the Labor Act. Now, by virtue of Section 254C1, paragraphs F, G, and H and subsection 2 of the 1999 Constitution as altered, this court is empowered to apply international best practices in labor, employment and industrial relations, and the application or interpretation of international labor standards. Thus, any act of any employer contrary to the provision of ILO Convention, ditto international labor standard, is to be held to be an unfair labor practice. It thus flows from the provisions of the ILO Convention, the Nigerian Labor Act, as well as the case law authorities cited supra, that the second defendant's action of withholding claimants' end salary for the months of May and June 2019 is a gross violation of his right to enjoy his salary, I so find and hold. Claimant by his relief D1 is asking for an order compelling and directing the second defendant to pay his monthly salary from May 2019 until the determination of this suit. It has been found earlier that the claimant's employment has been constructively terminated from today by the court. Does that entitle the claimant to salaries from July to date? The answer to this question is in the negative. This is in view of the tried position of the law that an employee is only entitled to salaries for work done and not entitled to salaries for work not done. So the cases of CCB Nigeria Limited and Wako, the case of Balogun and Union Bank citation captured, Olatubos and NISA citation provided. Thus, this court does not have the jurisdiction to compel the first defendant to pay the claimants from May 2019 to date. In view of the above, I find that release 4D fails. The claimant by his relief D2 is praying the court to urge the defendant to ensure payment of his pension for 17 years. The claimant submitted that the first defendant has been remitting part of his salary to the pension fund and show cause vid Exhibit L10. From the clear interpretation of Exhibit L10, it is obvious that the claimant is not alleging that his pension was not remitted to his PFE. Instead, is asking for the court to compel the first and second defendants to ensure the payment of these accrued pension to him. It is plain on Exhibit L10 that the claimant has an RSA account with his PFE, Stanbic IBTC pensions. It is equally clear that he has access to the funds. The only role that the defendants can play is to write a letter to the PFE stating that claimant has determined his relationship with them and that he should be accorded any assistance in assessing his pension. I thus find that relief D1 succeeds only to the extent that the defendant should write a letter to the claimant's PFA to accord him any support he may require to enable him access his pension. The claimant by his relief is seeking for an injunction restraining the defendants from doing anything that may adversely affect the claimant. I find this relief unnecessary in view of the reasoning of the court at paragraph 38 of this judgment, which is to the effect that claimant's employment has been constructively terminated by the defendants. Hence, there is no more relationship with the trial, consequent upon which I find no justification for the grant of relief E. Relief E is accordingly discountenanced. Claimant in his relief is praying for the sum of 2 million naira as general damages for physiological trauma the claimant went through against the first defendant. I find no evidence on record to evidence that claimant went through any physiological trauma. There's no medical report or no evidence to substantiate this claim. Reliefs are not granted as a matter of course. An applicant in this instance has the task of proving that in fact he went through a physiological trauma in view of non-payment of salary by the defendants. Claimant in his relief G. This relief is thus discountenance. Claimant by his relief G is praying for the sum of 20 million naira as general damages for physiological trauma the claimant went through against the second defendant. The issue of theft only came to the fore in the course of the trial of this case, and so that wouldn't have caused any trauma to the claimant since 2019. It is in my humble view that claimant has failed to prove with credible evidence that he suffered any physiological trauma to warrant the award of any damages. Relief G thus fails. Claimant by his relief I seeks for cause of action. The law is settled that costs, including costs of litigation, is at the discretion of the court. The rules of this court, particularly Order 55, empowers the court to grant cause of action at the discretion of the court. It is also the law of commonplace that a successful party is entitled to costs, which he should not be denied except for good reasons. The claimant in this instance suit has succeeded in the most part of his claim. I therefore do not find any reason why I should not exercise my discretion to award costs in his favor. I consequently award the sum of 100,000 naira as cost to the claimant, and this is to be paid by the defendants each. Each of the defendants will have to pay 100,000 naira cost to the claimant. The second defendant counterclaimant set up a claim against the claimant. Law is well settled, that is issue 3. The law is well settled that a counterclaim is a separate and independent action, which is usually appended to the main or principal claim for convenience of determination. See the case of Faloye and Faloyo citation capture. The defendant's counterclaimant is duty-bound to prove its counterclaim just like a normal action. The claimant is said to rely on the strength of his case and not on the weakness of the defendant's case. Counterclaimant by its relief A is asking for a declaration that the employment of the defendant to the counterclaim with the counterclaimant has been terminated by a notice of termination of contract dated 2nd July 2019. I've held supra in this judgment that the letter of termination was never served on the claimant by the defendant. It is in view of this that I find that the second defendant's counterclaim A fails. Counterclaimant by its relief B is asking for a declaration that the defendant to the counterclaim is entitled to his outstanding salaries, is not entitled to his outstanding salaries of 2 months of May and June 2019, or whichever sum is entitled from the counterclaimant upon the cessation of his employment on the 1st of July 2019, until he properly hands over and deliver all the properties given to him by virtue of his employment with the counterclaimant, particularly the Geregu Power PLC identity card he retains after the cessation of his employment. It has been held that claimant's employment has been constructively terminated today. Therefore, I give an order to the claimant to surrender the first defendant's identity card in his custody to the defendants. Relief B only succeeds to that extent. I so order. The counterclaimant by its relief C is asking for a declaration that the defendant to the counterclaim is indebted to the counterclaimant in the sum of 3,450,000 naira, being the value of the 750 liters of condensate stolen by the defendant to the counterclaim at the Geregu Power Plant Station, where he was posted by the counterclaimant. As earlier held in this judgment, the burden of proof on the second defendant to prove is approved beyond reasonable doubt its allegation of theft, which was not satisfied and thus not proved. The allegation made against the claimant is one that must be proved beyond reasonable doubt, as I stated earlier. More so, the second defendant counterclaimant is here claiming that the worth of the condensate is 3,450,000, being the value of 750 liters of the condensate. This is a special damage that needs to be specifically pleaded and proved. The second defendant counterclaimant failed to provide any evidence to substantiate his claim for the above sum. There is no invoice or receipt or any other evidence to prove that the value of the condensate is 3.450. It is in view of all stated in this judgment that I find that the second defendant failed woefully to prove its relief C. Accordingly, relief C fails. Counterclaimant by its relief D is in the alternative praying for a declaration that the defendant to the counterclaim is liable to return the 750 liters of condensate he carted away from the Geregu Power Plant Station, where it was posted by the counterclaimant. I've held that the second defendant failed to prove beyond reasonable doubt that the claimant stole its condensate. It is thus without equivocation that I find and hold that the second defendant's relief D also fails for want of proof. Counterclaimant by its relief E is seeking for a declaration that the counterclaimant is entitled to net off the outstanding salaries of 2 months of May and June 2019, or whichever sum the defendant to the counterclaim is entitled from the counterclaimant upon the cessation of his employment on the 1st July 2019 to defray the sum of 3,450,000 naira, the value of 750 liters of condensate stolen by the defendant to the counterclaimant at the Geregu Power Plant Station. This relief will suffer the same fate as the other penultimate release. This is because there is no award of money for which the second defendant can net off, as it puts it. The main relief having failed, the prayer of the defendant also must fail. Accordingly, relief E of the counterclaim fails. Counterclaimant by its relief F is seeking for an order of this honorable court directing the defendant to the counterclaim to properly hand over and deliver Geregu Power PLC identity card issued to him by virtue of his employment with the counterclaimant. I've already granted this order hearing before at paragraph 46 of this judgment. Counterclaimant in relief G and H together with obvious reasons. I'm taking both together for obvious reasons. The counterclaimant is praying for an order of this court directing the defendant to the counterclaim to pay the sum of 3,450,000 naira, being the value of 750 liters of a condensate stolen by the defendant to the counterclaim at Geregu Power Plant Station, or in the alternative, to direct the defendant to the counterclaim to deliver 750 liters of a condensate he stole at the Geregu Power Plant Station, where it was posted by the counterclaimant. These allegations made has been found from the above to be unsubstantiated. It thus goes without saying that these two reliefs must equally fail. They does fail. Counterclaimant by its relief I is asking for the court to grant cost of this action, which is assessed at 500,000 naira. It is a law of commonplace that a successful party is entitled to cost. See the case of Kappa and Alberto Nigeria PLC and NDIC citation captured. It is obvious from the reasoning of the courts respecting the counterclaims that the second defendant counterclaimant failed in its release. The consequence of this is that the counterclaimant is not entitled to any cost. Consequently, relief I fails. In sum, it is apparent from all the above that the claimant's claims succeed in the most part, and the second defendant's counterclaims fail in its entirety. I therefore make these declarations and orders. 1, that the claimant's case as constituted is competent and there is a cause of action against the first defendant. 2, there exists a tripartite employment relationship amongst the parties in this suit. 3, claimant's employment is constructively terminated today. 4, the second defendant is to pay claimant his May and June 2019 salary, which is a total sum of 178,000 naira. 5, claimant is to surrender the first defendant's ID card to it. 6, the second defendant's counterclaims fail in its entirety. 7, each of the defendants is to pay the cost of 100,000 naira to the claimant. And 8, this judgment is to be complied with by both defendants within 14 days of this judgment, failing which it is to attract a 10% simple interest per annum. Judgment is accordingly entered. We took the light away, but I hope you can still see me and hear me.
As the court pleases, my noble lord, are grateful for the well-considered judgment, and we promise that the defendant shall comply as directed by the Honorable Court.
Very well.
We're grateful for the well-considered judgment of the Honorable Court. Most obliged.
So copies of the judgment will be sent to Lokoja for you to have them.
As the court pleases.
As the court pleases. We are indeed grateful, my lord.
We are most grateful, my lord.
So the court will rise now. All right.
Thank you so much.